Hello, I'm Father Joe Fowler.
And I'm Father Steve Olson.
Chances are, if you're watching this, you're either awaiting a decision for a formal case from our tribunal, or you recently received a notification of a decision and want to know more about what that means. Hopefully, this video will help you to understand the most common possible outcomes of a formal case for marriage nullity. When you receive a decision from the tribunal, it will either be an affirmative or a negative decision. Formal cases lead to a decision about the nullity of marriage, either affirmative, meaning that the declaration of nullity is to be granted, or negative, which is against nullity.
An affirmative decision means that the marriage in question has been proven to be null, or an attempted marriage did not actually take place in the eyes of the Church because of the reasons which will be outlined in the decision. There was at least one important key factor that made the consent of either the bride or groom or both invalid at the time of the wedding, meaning that the marriage itself was also invalid from the beginning. Please note that an affirmative decision for nullity doesn't make claims against civil divorce effects, such as the status of any children, alimony, or any other civil effects. Because a petitioner is the one who initiates the process, an affirmative decision is usually considered good news for the petitioner, and it means that this attempt at marriage is no longer considered valid. If the petitioner or the respondent wish to attempt marriage again in the Catholic Church, then the marriage that has been declared null is no longer an impediment. Now, there may be other impediments that do, however, continue to exist, so receiving an affirmative decision does not always mean that either party is free to marry in the Church.
These decisions aren't only about the petitioner, though. If the decision comes out in the affirmative, then the respondent's marriage status is going to change as well. The respondent may wish to appeal the decision, but we'll discuss appeals at a later point in the video. It's always good to remember that the respondent in a formal case can either participate in the process or not. They may choose not to participate. If they do choose to participate, they may be participating and offering testimony in favor of nullity, agreeing with the petitioner, or they may be contesting and providing testimony against the petition. The tribunal has the duty to inform the respondent of all the key steps of the process, to preserve their rights, to assist them along the way, and to provide an advocate if they request one. The defender of the bond also has a say regarding affirmative decisions, but we'll wait to mention that until we talk more about appeals and negative decisions.
Next, we're going to talk about an affirmative decision with a monitum or a vetitum, also known as a warning or prohibition, respectively. Sometimes, along with an affirmative decision, factors contributing to the breakdown of a contested marriage may have an ongoing effect and may need to be resolved to the satisfaction of the judge. So, in order to safeguard the dignity of any future attempted marriage, a monitum or a vetitum may be imposed along with the decision. A monitum is a warning about future marriage in the Catholic Church. If a monitum has been issued on either the petitioner or the respondent, then normally the clergy responsible for preparing the person for a new marriage in the Church is to be made aware of the factors in question before he or she can be married in the Catholic Church. A vetitum is a prohibition against future marriage in the Catholic Church. This is a more serious restriction prohibiting that person from entering into a new marriage until certain conditions have been met. Those details will be carefully specified in writing in the final decision of the tribunal. A vetitum must be lifted by the tribunal in order for the party to lawfully marry in the Church.
So what do these look like in practice? To demonstrate, we'll offer a few examples of why a monitum, a warning, or a vetitum, the prohibition, might accompany a tribunal decision. For a monitum, we'll take the example of a person who's already attempted marriage several times in the past. The judge might have concerns about their understanding of permanence or their ability to live the obligations of married life. For this reason, he may insist, by imposing a monitum, that the priest or deacon responsible for preparing either party for a new marriage in the Church be made aware of the events contributing to the nullity of the person's previous marriage. For a vetitum or a prohibition, we can take the example of a person who suffered from some form of debilitating addiction, and maybe that addiction prevented them from being able to live the duties of married life. The fact that the person has been divorced and received a declaration of nullity doesn't resolve the problem that led to the failed marriage. The judge may impose a vetitum or a prohibition in this situation and require, for example, that in order to marry lawfully in the Church, the person must provide a letter from an addiction counselor, participation in a recovery program, and manifest an ability to live a healthy life with ongoing treatment as conditions for the vetitum to be lifted. All of the details will be laid out in the text of the decision. The person would not be free to marry in this situation in the church until the tribunal has lifted the vetitum once those conditions had been met.
Now that we've discussed affirmative decisions, it's time to take a look at negative decisions. A negative decision means that the judge was unable to conclude that the marriage was null based on the evidence and testimony given. This is nearly always crushing news for the petitioner, but the reality is that not every petition for nullity can result in an affirmative decision. This is why no guarantees can be made when someone decides to submit a petition for nullity. But before any other conclusions about the decision are made, let's consider what this means and what this does not mean. We'll also discuss a few options that are available if a negative decision is reached. Let's start by talking about what a negative decision means. In a canon law perspective and juridic perspective, the marriage remains valid until it can be proven otherwise. If the petitioner or the respondent is Catholic and has already remarried outside of the Catholic Church, he or she should discuss the possibility of receiving Holy Communion with their pastor.
What a negative decision does not mean is that the church intends for the couple to get back together. That's not the intention of the church. It's not the vision of a negative decision. A negative decision is not a moral judgment on a person's character or even their decisions. It's not a judgment about whether or not you're a good person. It's not a judgment of a person's eternal soul. God determines that alone. But the church has the authority to determine who is free to marry according to the teachings of Christ and the laws of the Catholic faith. A negative decision may restrict the status of marriage, but the parties are not shunned, they're not excommunicated, they're not exiled from the church as a result of a negative decision. In fact, a divorced Catholic is not automatically disqualified from receiving Holy Communion, provided that they have not remarried without permission. This is one of the most difficult parts of the annulment process, and it's why we want to address it in this video.
Now we're going to talk about some options following a negative decision. The first option is an appeal. The Marriage Tribunal of the Diocese of Pensacola-Tallahassee is an example of a first instance court. No case may be retried at the same level under the same grounds, and so an appeal can be made to the court of second instance or to the court of third instance. For us, the second instance court is in Miami, and the third instance court is the Holy See in Rome. If deciding to appeal the decision of first instance, expect fees related to that appeal. That same evidence and testimonies, and possibly including more evidence and testimonies, might be necessary in order to support the appeal process. Now, either the petitioner or the respondent may appeal a decision. It's also possible that the defender of the bond can appeal, but it would more likely be that the defender would appeal an affirmative decision, since it's the defender's job to uphold the marriage bond.
Another option of what you might do receiving a negative decision is to form a new petition in the first instance, here at the tribunal in Pensacola-Tallahassee. But in order to do this, new grounds would have to be established. The grounds are the fundamental reason for which a declaration of nullity is granted or not granted. If you're already participating in a case and have received a decision, at some point along the process, you would have received a decree of joinder, and that would have identified for you or told you the grounds upon which your case was to be tried. If you should choose to resubmit the case under different grounds, it'll be important for you to discuss with your advocate the possibilities of what those grounds might be.
Another option would be to make no appeal and to make no new petition. This would mean allowing the decision to stand, and however, some people might not be happy with the decision because it fails to resolve their marriage situation. If you're not interested in remarriage, then it may be possible to accept the negative decision with no further action. But if you wish to be married in the Catholic Church or can validate your current non-Catholic marriage, then you may want to appeal or attempt to petition with new grounds.
Another option about which many people are unaware is requesting an official separation from your canonically valid spouse. The marriage bond presumes conjugal living, married living, and other obligations. The vision of married life is a marriage of communion, communal life together. For civilly divorced couples who are no longer together and have not had their marriage annulled, a request can be made to the diocesan bishop to live separately from one another. Even though the marriage would still be canonically valid, the parties may be relieved from the obligations of certain aspects of the marriage. Contact the tribunal if you'd like to learn more about how to do that. This course of action does not make a person free to marry again in the church, but liberates the couple from the obligations of married life.
Finally, I think probably the most important option after receiving a negative decision or an affirmative decision is to pray. We recognize that our work in the tribunal has a component of healing ministry to it, and we're constantly praying for all of the people whom we serve in the tribunal, even when it's difficult to understand or explain the laws or the teachings of the Catholic Church.
Father Olson and I both hope that this video is helpful in explaining the outcomes of the formal case process. We know how difficult this can be, how strenuous this can be, and how much work it takes to submit a case to our tribunal. We don't take that lightly. If you have further questions, please contact us at the tribunal or reach out to your local parish priest. And thank you for watching this today.